Welcome to the My Path to Safe Housing Initiative Learning Series, your trusted resource for homeowner legal education and consumer protection. This course is designed to empower you with the knowledge and confidence needed to protect your home, finances, and rights under Massachusetts law. Our mission is to educate, equip, and empower every homeowner to make informed decisions, recognize unfair or deceptive business practices, and seek justice responsibly. Throughout this series, you'll learn to identify fraudulent contractor practices, understand your protections under key Massachusetts laws, and develop practical skills for representing yourself if necessary. You'll also gain insights into working with government agencies and organizing critical documentation. Let's begin this journey together towards safer, smarter homeownership. Before we dive in, please note, this course is for educational purposes only and does not provide legal advice. If your situation is complex or you are unsure about self-representation, consult a licensed attorney or reach out to the Massachusetts Bar Association for professional guidance. As you proceed, remember that you are responsible for your own legal actions, and state or federal agencies cannot offer individualized legal representation. To maximize your learning, organize your documents in a dedicated folder, review all materials before starting Module 1, take careful notes on definitions and agency contacts, and always maintain professionalism. Your credibility is your strongest asset. Empowerment through education starts here. By learning the law, you're taking the first vital step to protect your home, your family, and your peace of mind. Remember, knowledge isn't just information, it's power guided by wisdom. Through this course, you'll reclaim the authority to stand firm, make informed choices, and act with discernment. Justice and faith go hand in hand. By understanding your rights and responsibilities, you serve both truth and your community. As Hosea reminds us, "My people are destroyed for lack of knowledge." Let each lesson strengthen your role as protector and advocate, building a foundation rooted in both faith and understanding. Module 1 begins by introducing your rights as a homeowner in Massachusetts, a state where property ownership is both a significant investment and a protected right. The law provides robust consumer protections, from building codes to contract regulations, all designed to ensure your safety and uphold ethical standards in home improvement. Key statutes like the Home Improvement Contractor Law and the Consumer Protection Act set clear rules for contracts, licensing, fair practices, and remedies. Yet many homeowners, especially first-time buyers, seniors, and environmental justice community residents, still fall victim to fraud or negligence. This module equips you to recognize risks and assert your legal protections. This section is your foundation. It outlines the rights you're guaranteed under Massachusetts law and explains contractors' responsibilities. Most importantly, it emphasizes how crucial documentation is when facing disputes. By understanding how your rights are protected and what steps you need to take, you'll be able to safeguard your property, prevent financial losses, and advocate effectively for yourself and your loved ones. At MPSHI, we believe that education is your best defense against exploitation. Throughout this manual, remember, if it's not in writing, it's hard to prove. If it's documented clearly, it's hard to ignore. Stay proactive. Documentation is power. Let's take a closer look at what you are entitled to as a homeowner under Massachusetts law. These rights are not just suggestions. They are embedded in state statutes, federal consumer protections, and case law, ensuring that every homeowner is treated with fairness, transparency, and respect. First, you have the right to a fair written contract for any home improvement work over $1,000, as required by Massachusetts General Laws, Chapter 142A. This contract must clearly outline the total project cost, timeline, scope, and payment terms, so you know exactly what to expect. You also have a 3-day right to cancel contracts signed in your home, thanks to the FTC cooling-off rule and Chapter 93A. Any changes in the scope of work require your consent and written approval through change orders. All work must be performed by licensed and insured professionals, and you are entitled to copies of building permits, occupancy permits, and signed approvals or failures. The work must meet both state and local building codes, and if something goes wrong, you have access to enforcement agencies for support. These rights are your foundation for safe, accountable, and successful home improvement. Why does this manual exist? It's your legal roadmap, created to answer the questions every homeowner faces after a negative experience. What are my rights? What laws protect me? What can I do when things go wrong? This guide will help you screen contractors effectively, understand which laws apply to your situation, use state and federal complaint processes confidently, file claims for damages or enforcement if necessary, and locate help, even if you can't afford a lawyer. If you need language access or accommodations due to disability or limited English proficiency, those rights are included too. Use this manual as your trusted companion. Let's examine common mistakes homeowners make and how you can avoid them. Failing to get a written contract means no proof of agreement. Always insist on one. Paying large deposits in cash leaves no paper trail. Choose checks or credit cards instead. Not verifying licenses or permits could result in illegal or unsafe work. Always check credentials at mass.gov and demand permits. Don't let contractors pull permits in your name unless you're managing the project yourself. Otherwise, you could be liable for their mistakes. Finally, never ignore red flags. Trust your instincts and document everything. Smart prevention is always better than costly repairs. Massachusetts homeowners are fortunate to have some of the strongest legal protections in the country, but these protections are only as effective as your knowledge of them. Many homeowners don't realize that the law is on their side until it's too late. Unfortunately, dishonest contractors often count on this lack of awareness, hoping you won't know what they're required to do or how to hold them accountable. That's exactly why the My Path to Safe Housing Initiative manual was created, to bridge the gap between complex legal language and practical, everyday understanding. This summary section is a crucial reminder that your rights are not automatic. You must know them and be prepared to enforce them. The manual's purpose is to empower you, the homeowner, with the information and confidence needed to stand up for yourself and your property. In the next section, we'll dive deeper into the specific consumer protection laws that regulate contractor conduct in Massachusetts. You'll learn about the statutes that provide legal remedies when things go wrong, and how you can use these laws to protect your home, your finances, and your peace of mind. By understanding your rights, you're taking the first step towards safe, secure, and fair housing. Massachusetts is recognized nationwide for having some of the strongest consumer protection laws, especially when it comes to home improvement and renovations. Two key statutes form the backbone of your legal defenses: Chapter 93A, known as the Consumer Protection Act, and Chapter 142A, the Home Improvement Contractor Law. These laws set strict rules for contractor conduct, covering everything from licensing and advertising to contract details, cancellation rights, and dispute resolution. As a homeowner, you're empowered to file complaints, seek triple damages for willful violations, and even access the state's HEC Guarantee Fund if a contractor fails to deliver. This legal armor ensures you have real power when disputes arise. This section of the My Path to Safe Housing Initiative manual is designed as a practical guide to help you, as a Massachusetts homeowner, fully understand your rights and the obligations that contractors must meet under the law. You'll discover exactly what rights you have under each relevant statute, so you can recognize when those rights are being respected or violated. The guide also details what contractors are legally required to do, from providing clear contracts to following through on promised work. It explains what constitutes a violation or deceptive practice, such as misrepresenting services, hiding fees, or failing to deliver on contractual promises. Most importantly, you'll learn the steps you can take if you encounter problems: how to file a formal complaint, how to recover damages, and how to escalate enforcement if necessary. By mastering these key points, you're equipping yourself with the knowledge and confidence needed to protect your property, your finances, and your peace of mind. Remember, understanding how these laws work and how to apply them in real situations gives you the power to stand up for your rights and ensure fair treatment in every home improvement or repair project you undertake. Let's take a closer look at M.G.L. Chapter 93A, the Consumer Protection Act. This law stands as a shield against unfair and deceptive acts in business dealings. If a contractor lies, hides costs, omits important information, or pressures you into rushed decisions, they may be violating Chapter 93A. The law applies to both businesses and individuals, covering everything from false advertising to hidden fees. If you're harmed by such practices, you have the right to take legal action. And if the violation is found to be willful, courts may award triple damages plus attorney's fees. A landmark case, Commonwealth v. Dakotas, helped define these protections for all consumers. The Massachusetts Supreme Judicial Court's decision in the Dakotas case is a turning point for consumer protection, and it's essential for every homeowner to understand its impact. The court ruled that businesses can violate the Massachusetts Consumer Protection Act, known as Chapter 93A, not only by outright lying, but also by acting unfairly or failing to disclose important information that misleads consumers. This means that even if a contractor doesn't tell a direct lie, leaving out key facts, failing to disclose fees, or charging for work that was never performed can still be considered a violation of the law. The Dakotas case originally involved mobile home fees, but its legal principles now apply to all consumer transactions, including those involving housing, energy, and contractor services. For homeowners, this case helps define what qualifies as unfair or deceptive behavior and reinforces the protections offered by the My Path to Safe Housing initiative. It's especially important for vulnerable consumers, such as seniors, people with disabilities, and low-income homeowners who are at greater risk of being targeted by predatory or exploitative business practices. The details of the case show how a mobile home park operator charged residents a resale fee for no legitimate service, a practice the court found to be both unfair and deceptive. This precedent empowers you to challenge similar conduct and demand transparency and honesty in all your dealings. In this landmark decision, the court ruled that charging homeowners fees for services never performed, like the infamous resale fee, was both unfair and deceptive under Chapter 93A. The ruling ordered refunds and permanently stopped such practices. Importantly, deception doesn't always require an outright lie. Charging for unperformed services or hiding crucial facts can also violate consumer law. As a homeowner, you have the right to demand transparency and fair dealing. If you're billed for permits or inspections never completed, hit with unexplained administrative fees, or kept in the dark about project costs or warranties, you may have grounds for a Chapter 93A claim. Real-life scenarios reveal just how easily homeowners can fall victim to contractor deception. Imagine being pressured into signing a contract by a fake rebate offer, only to find out later that no such rebate exists. That's considered deceptive inducement under Massachusetts law. Or suppose you're charged a hefty permit fee on your invoice, but no permit was ever obtained. Billing for non-existent services is a clear violation of your rights and mirrors the very practices struck down in landmark court cases like Dakotas. These examples highlight why it's so important to stay vigilant and know when your legal protections apply. Deceptive billing practices are unfortunately all too common in the world of home improvement and construction, and understanding these scenarios is vital for every homeowner. Consider the first example. Your final invoice includes a $500 fee for site cleanup, but when the project is finished, your property is still littered with debris, nails, and hazards. Billing for work that was never actually performed is not just unethical, it's illegal. The law is clear. You are protected from paying for empty promises and services you did not receive. In another scenario, you agree to a $12,000 kitchen remodel only to find a $1,200 administrative processing fee added after work begins, buried in small print and never explained. This failure to clearly disclose all charges up front is considered an omission of material fact, which is deceptive under consumer law. Finally, imagine paying $5,000 up front for custom windows, only to discover that the contractor never ordered them and cannot provide receipts or proof of delivery. Taking money for goods never ordered is not only a violation of Chapter 93A, but may also constitute larceny by false pretenses under Massachusetts law. These examples highlight the importance of vigilance and knowing your rights, so you can spot, challenge, and report deceptive practices before they cause lasting harm. Another common problem is falsifying labor hours. Imagine being billed for 40 hours of work in 1 week when you know the contractor was on site for less than 10. Inflating labor hours is fraudulent billing, a practice that can trigger both civil and criminal penalties under Massachusetts law. Each scenario we've covered demonstrates how the law shields you from contractors who lie, add hidden fees after work begins, or accept payment for undelivered goods. Remember, you have the right to challenge these practices in court, and if you prove willful wrongdoing, you may even be entitled to triple damages plus legal fees. Module 1.7 introduces Massachusetts Chapter 142A, a vital law protecting homeowners during residential renovations. Enacted in 1992, this law ensures that if you own and live in a home with up to 4 units, contractors must follow strict rules. These include mandatory registration, proper insurance, written contract standards, and important consumer protections. For any home improvement project costing more than $1,000, your contractor is legally required to provide a written contract. This contract must clearly state the contractor's home improvement contractor registration number, the total price of the job, a fair payment schedule that prohibits paying everything up front, and a detailed description of the work to be done. These requirements are designed to safeguard your rights and set clear expectations from the start. In addition to outlining required contract elements, Chapter 142A sets clear boundaries for contractor conduct. Your contract must specify start and completion dates, inform you of your 3-day right to cancel, and include signatures from both you and the contractor. If any of these are missing, the law is violated, and you may be entitled to remedies or compensation. The law also strictly prohibits certain behaviors. Contractors cannot begin work before a contract is signed, misrepresent their credentials, use undisclosed subcontractors, demand full payment upfront, or ignore building codes and permits. These actions are classified as unfair or deceptive practices under Massachusetts consumer protection laws, meaning you have legal recourse if they occur. As a homeowner in Massachusetts, you're protected by several legal safeguards if problems arise with a contractor. First, you can use the state's Home Improvement Contractor Arbitration Program to resolve disputes quickly, often without going to court. This saves time and helps avoid costly legal fees. Second, if your contractor is properly registered and you experience losses from faulty work or unfinished jobs, you may be eligible for up to $25,000 in compensation through the M.G.L Guarantee Fund. Importantly, you don't always need to file a lawsuit to receive compensation, making the process simpler and faster for homeowners seeking solutions. Stay updated on procedures through the official M.G.L website for the latest guidance. To access the Guarantee Fund's protections, certain criteria must be met. The contractor must be registered with the Office of Consumer Affairs and Business Regulation, and you need to file your complaint or arbitration request within specific legal time limits. Your claim should involve issues like breach of contract, incomplete or shoddy work, unpermitted projects, code violations, or other home improvement contractor violations. If you suspect your contractor broke the law or need help with a complaint, contact the Consumer Hotline at 617-973-8787 or visit mass.gov/HIC. You can also look up contractor registrations online to ensure they're properly qualified before hiring. Section 1.8 highlights real-world violations and how Massachusetts law empowers homeowners to respond. For example, if a contractor fails to provide a written contract, Chapter 142A allows you to file a complaint with the Office of Consumer Affairs. Misleading claims about rebates or timelines fall under Chapter 93A. Here, you can send a demand letter or pursue court action. Unauthorized charges can be reported to the Attorney General or resolved in small claims court. Starting work without proper permits breaks both building code and Chapter 93A regulations. Notify your local building department and the Attorney General. If your 3-day cancellation right isn't honored, both state and federal laws provide enforcement paths so you can protect your interests. Before taking legal action on your own, it's crucial to understand this educational course provides information, not legal advice, and does not create an attorney-client relationship. If you're unable to represent yourself in accordance with Massachusetts laws, seek guidance from a licensed attorney or local bar association. State and federal agencies do not offer legal advice. Instead, they may refer you to legal aid organizations or attorneys. These agencies can investigate complaints and provide public information, but won't represent you in court or review your legal strategy. If you choose self-representation in any court, you're responsible for following all rules of civil procedure and ensuring your documents and deadlines are correct. Massachusetts law provides homeowners with a robust set of enforcement tools to protect their rights and recover damages when dealing with contractors. One of the most important steps you can take is to send a Chapter 93A demand letter, as outlined under the Consumer Protection Act. Before you can file a lawsuit under M.G.L. Chapter 93A, you are required to send this formal demand letter to the contractor. The letter should include a clear and concise explanation of what happened, specifically identifying the legal or contractual violation that occurred. It's essential to state the remedy or solution you are seeking, such as a refund, repair, or payment, and to set a firm deadline, typically 30 days, for the contractor to respond. To strengthen your case, always attach supporting evidence like photographs, videos, invoices, contracts, permits, or any relevant text or email communications. Remember, it's crucial to stick to the facts and avoid accusations, slander, or emotional language, as this letter may later be used in court. By following these guidelines, you ensure your demand letter is both effective and admissible, giving you a strong foundation for any further legal action you may need to pursue. Understanding why these enforcement steps matter is crucial for every homeowner. If a contractor fails to respond reasonably to your Chapter 93A demand letter, they may be held liable for triple damages and attorney's fees under Massachusetts law. This powerful consequence is designed to encourage contractors to resolve disputes fairly and promptly. If the issue remains unresolved, your next step is to file a complaint with the Office of Consumer Affairs and Business Regulation, or OKBAR, which oversees the Home Improvement Contractor Program. Filing a complaint is appropriate if you've experienced unlicensed or substandard work, suspect fraud or misrepresentation, or want the state to investigate licensing violations. The process is straightforward. You can call the consumer hotline at 617-973-8787 for guidance, or visit mass.gov to file your complaint online and access additional resources. The website also provides step-by-step instructions on how to write an effective 93A demand letter. By taking these actions, you not only protect your own interests, but also help uphold standards for all Massachusetts homeowners, ensuring safer, more reliable home improvement experiences for everyone. If a contractor refuses or is unable to pay after you win a judgment or arbitration award, you may be eligible for reimbursement up to $25,000 through the HIC Guarantee Fund. To qualify, the contractor must have been registered at the time of the contract. You must have attempted to collect the judgment, and the claim must involve a residential owner-occupied home with up to 4 units. For more information, you can visit mass.gov. If your claim is under $7,000, Small Claims Court offers a fast and affordable path. No attorney required. Simply file your complaint at your local district court, bring all relevant documents and evidence, and be ready to present your case clearly. For step-by-step guidance, consult the Small Claims Court Guide on mass.gov. Filing sui juris in civil court means you are representing yourself as a competent adult or as a trustee of a private trust, not as a corporation. This approach is especially relevant if you're acting on behalf of a trust, faith-based ministry, or exercising your constitutional rights. While courts may not always officially recognize sui juris in place of pro se, using both terms can help clarify your legal standing. To start, file your complaint and civil action cover sheet with your local district or superior court, review the Massachusetts Rules of Civil Procedure, and seek assistance at your courthouse's law library or court service center. Before you decide to represent yourself in court, it's essential to understand the responsibilities and expectations that come with acting as your own legal advocate. The law does not make exceptions for those without legal training. Ignorance of the law is not a valid excuse, and you will be held to the same standards as a licensed attorney. For homeowners, this means that if you choose to proceed pro se or sui juris, you must take full ownership of your case. This includes conducting your own legal research, learning how to properly serve documents, drafting a civil complaint, and presenting your evidence in a clear and organized manner. You'll also need to understand the rules that govern contract enforcement, consumer rights, and the specific procedures of civil court. To get started, it's wise to familiarize yourself with the differences between small claims and civil court, which you can do by visiting resources like mass.gov. If you're filing without a lawyer, it's crucial to keep detailed records of all communications with contractors, including emails, letters, photos, and signed contracts. Maintaining professionalism and respect in all your legal filings and interactions with the court will help ensure your case is taken seriously and handled efficiently. Organization is a cornerstone of effective self-representation in any legal matter. As you prepare your case, it's vital to maintain both physical and digital folders for all your documents, correspondence, and evidence. This level of organization not only helps you keep track of important deadlines and filings, but also demonstrates to the court that you are taking your responsibilities seriously. When presenting your case, avoid using slander, defamation, or inflammatory language, as these can undermine your credibility and distract from the facts. It's equally important to steer clear of excessive legal jargon or so-called sovereign citizen arguments, which may confuse your position and weaken your case. Instead, focus on presenting clear, factual evidence and referencing the applicable laws that support your claims. For guidance on proper legal procedures and document formatting, consult the Massachusetts Rules of Civil Procedure, which are available through mass.gov. These rules provide a framework for how to structure your filings, serve documents, and interact with the court. By staying organized, sticking to the facts, and following established legal protocols, you greatly increase your chances of a successful outcome in your case. When you choose to represent yourself in court, you take on several critical legal obligations that are essential for the success of your case. First, you must properly draft and file all legal documents, including motions, complaints, and evidence, using the correct legal formats required by the court. This means paying close attention to detail and ensuring that every document you submit meets the necessary standards. Serving the other party is another fundamental responsibility. You are legally required to deliver all documents to the defendant, whether that's a contractor, company, or other party, according to the specific rules of the court. Failing to serve documents correctly can result in your case being dismissed, regardless of its merits. Meeting deadlines is equally important, as every step in your case comes with its own timeline. Missing a court date or filing deadline can severely harm your case and may even lead to automatic losses. Finally, you must be prepared for courtroom procedures, which include appearing in court, presenting your evidence, questioning witnesses, and responding to motions from the opposing party. Mastering these obligations is key to navigating the legal process with confidence and achieving a fair resolution. Understanding and following the Massachusetts civil procedure is a fundamental requirement for anyone involved in a legal case, including those who choose to represent themselves. These rules govern every aspect of how your case is handled, from the initial filing to the final judgment, and they apply equally to all parties, whether you are an attorney or acting pro se. To help you navigate this complex process, several resources are available. The Mass.gov law libraries provide free legal research assistance and access to essential court forms, making it easier to prepare your case. The Massachusetts Rules of Civil Procedure offer detailed guidance on how to structure your filings and ensure compliance with court requirements. If you need additional support, the Legal Aid Finder can help you locate legal aid services in your area, and court service centers are available to assist with forms, case basics, and procedural steps right at the courthouse. By leveraging these resources and adhering strictly to the rules of civil procedure, you can approach your case with greater confidence and increase your chances of a favorable outcome, even without formal legal representation. As we conclude Module 1, it's important to review your legal rights under Chapter 142A, the Massachusetts Home Improvement Contractor Law. This law is designed to protect homeowners when hiring contractors for renovations or repairs on owner-occupied homes with up to 4 units. Contractors are required to be registered with the state, and for any job over $1,000, they must provide a written contract. This contract should include the contractor's HIC registration number, the total cost and payment schedule, ensuring that no full payments are made up front, clear start and end dates, a detailed scope of work, a statement of your 3-day cancellation rights, and signatures from both parties. These requirements are in place to ensure transparency and accountability. Additionally, contractors are strictly prohibited from starting work without a signed contract or from misrepresenting their licenses or insurance. By understanding these key requirements and prohibited actions, you can better protect yourself from potential fraud or disputes and ensure that your home improvement project proceeds smoothly and within the bounds of the law. Homeowners are protected by law against undisclosed subcontractors and safety code violations. Your legal protections include access to the HIC arbitration program for resolving disputes without going to court, and potential compensation up to $25,000 from the Guarantee Fund if contract violations occur. No lawsuit required if eligibility is met. Enforcement tools range from sending a Chapter 93A demand letter to filing complaints with OK Bar or applying for the Guarantee Fund. You may also file in small claims court for damages under $7,000 or represent yourself in civil court. For complex cases like contractor fraud or civil rights violations, hiring an attorney may be best, and if you win, they can request attorney fees be covered by the other party. Always reserve all rights when signing any contract using UCC 1308. This preserves your ability to challenge undisclosed terms later. When you represent yourself in court, your credibility and adherence to legal standards are paramount. Always tell the truth in all your dealings with the court, and whenever possible, include an authenticated affidavit of truth that is notarized to support your statements. This not only strengthens your case, but also demonstrates your commitment to honesty and integrity. It's important to remember that agencies like the Office of Consumer Affairs and Business Regulation, OCABR, do not provide legal advice, so you are responsible for understanding and following all relevant legal procedures. As a self-represented litigant in Massachusetts, you must be familiar with the Massachusetts Rules of Civil Procedure, file all motions, evidence, and responses correctly, and meet every deadline set by the court. Failing to follow these procedures can result in your case being dismissed or your arguments being disregarded. The court will hold you to the same standards as an attorney, so attention to detail, organization, and a thorough understanding of the law are not just recommended, they are required. By upholding these standards, you give yourself the best chance for a fair and just outcome. Welcome to Module 2, Federal Laws, Fraud, Organized Crime, and Financial Crimes. While many contractor disputes are handled at the state level, some cases are so serious that federal law comes into play. These laws address patterns of fraud and financial crimes, particularly when multiple victims are involved or when deception crosses state lines using tools like email or wire transfers. Federal statutes offer powerful remedies, including severe penalties like hefty fines, asset seizure, and even imprisonment. It's crucial to recognize when these federal laws apply. They can provide extra protection if a contractor or company has a record of exploiting consumers. One key statute is the RICO Act, cited as 18 U.S.C. for 1962. Originally designed to fight organized crime, RICO's civil provisions also cover any business or individual engaging in repeated fraud or illegal conduct that harms others. Understanding these laws can be vital for protecting your rights and the safety of your community. Federal laws like RICO are especially powerful when dealing with contractor scams that target multiple homeowners. RICO applies if a contractor repeatedly uses deceptive tactics, such as false advertising, forged permits, laundering money from fraudulent schemes, or even threatening and falsifying documents to avoid consequences. The legal remedies under RICO can be substantial. Victims may file civil lawsuits seeking triple the damages, known as treble damages, and recover attorney's fees. In especially severe cases, these actions can trigger federal criminal prosecution. For example, imagine a contractor who sets up several LLCs, takes deposits from dozens of homeowners, does minimal work, and then vanishes. In such cases, victims can pursue civil claims under RICO and report the matter to federal authorities like the FBI or U.S. Attorney. These tools give consumers real leverage against organized fraud. Wire fraud is another federal crime that can come into contractor disputes, especially when digital communication is involved. Under 18 U.S.C. Pike 1343, it is illegal to use interstate communications, such as the internet, email, text messages, or online banking, to deceive someone out of money or property. This law often applies if a contractor misleads you through email or text, sends fake invoices with bogus charges, or uses online payment links to collect funds for work never performed. Wire fraud is a serious felony with harsh consequences. Penalties can reach up to 20 years in prison and become even steeper if the scheme targets disaster relief programs or vulnerable populations. Recognizing these warning signs can help protect your finances and ensure that justice is served. Money laundering is a major federal offense that often accompanies fraud in construction scams. According to 18 U.S.C. 1956, this law aims to stop individuals or businesses from hiding, transferring, or spending money gained through illegal activities. It applies when contractors use shell companies to move stolen funds, accept off-the-books cash payments deposited into secret accounts, or try to disguise income from unlicensed work. For example, if a contractor sends you a fake invoice for $8,000, claiming material costs but never delivers those materials, and then funnels that money through multiple accounts, that's money laundering. The consequences are severe. Violators face up to 20 years in prison and large fines, and the government can seize assets gained from these crimes. Knowing how these laws work helps you spot red flags and protect yourself from financial exploitation. How do these federal laws apply to your case? This module provides a practical guide linking common scam situations with the relevant laws and recommended actions. If you and your neighbors are scammed by the same company, RICO may apply. Report it to the FBI or your state attorney general and consider a civil lawsuit for treble damages. If you receive false invoices by email, wire fraud statutes kick in. Report these incidents to your attorney general, the FTC, or law enforcement. When contractors collect large deposits then disappear, both wire fraud and RICO could be involved. Prompt action includes filing complaints and contacting legal aid or even the U.S. Postal Inspector. Finally, if money is moved through fake LLCs or aliases, money laundering laws may come into play. Contact federal enforcement agencies like the IRS or FBI immediately. This table arms you with the right steps for each type of fraud. After natural disasters, like hurricanes, floods, or fires, homeowners are especially vulnerable to contractor fraud. High demand for emergency repairs creates an opportunity for unlicensed or predatory contractors to exploit desperate situations. Watch out for storm chaser contractors who travel across states targeting disaster areas, those who promise quick repairs but demand large cash deposits up front, those who disappear after taking your money, deliver shoddy or unpermitted work, or forge insurance documents and misrepresent rebate programs. These practices aren't just unethical, they're illegal under Massachusetts General Laws, Chapter 142A and Chapter 93A. Staying alert after a disaster can help protect your home and finances from further harm. Protecting yourself in contractor disputes, especially when fraud or misconduct is suspected, requires more than just frustration or blame. It demands discipline, thorough documentation, and above all, ethical conduct. When you find yourself in a situation where you need to file a complaint or escalate an issue to government authorities, it is absolutely essential to act in good faith and always be truthful. Filing a complaint based on false accusations or misrepresenting facts can have serious legal consequences, including liability for defamation, perjury, or bad faith under both state and federal law. If, during the discovery process, it is revealed that you knowingly lied, exaggerated, or withheld key facts, your case may be dismissed, and you could even be sued in return. This is why it is so important to always act honorably and with integrity. The legal system is designed to protect those who are honest and diligent, but it also holds accountable those who attempt to manipulate the process. Remember, your credibility is your strongest asset. By acting in good faith, you not only protect your own interests, but also contribute to a fairer and more just system for everyone. Always document your actions, keep records of all communications, and ensure that every statement you make is accurate and supported by evidence. In the end, acting ethically and truthfully is the best way to safeguard your rights and achieve a positive outcome. Before escalating a dispute with a contractor to government agencies or courts, it's both a legal and ethical responsibility to attempt private resolution first. Most state agencies and courts expect evidence that you've made a genuine effort to resolve the issue directly with the contractor before filing formal complaints or lawsuits, a step that can prevent unnecessary delays or dismissals on procedural grounds. Start by sending written notice within 10 business days of discovering the problem. Use certified mail with return receipt or email with delivery confirmation. Clearly outline what went wrong, whether it's incomplete work, overbilling, or missed deadlines, and document your communication carefully. Demonstrating this good faith effort strengthens your case if escalation becomes necessary. When seeking to resolve a contract dispute, it's essential to clearly outline what was originally agreed upon, whether in writing or through verbal terms. Next, specify the resolution you are requesting. This could mean a refund for services not performed, necessary corrections or repairs, a third-party inspection, mediation, or simply a written explanation. To support your request, attach copies of all relevant documentation. This includes contracts or estimates, invoices and receipts, before and after photos, text or email messages confirming the agreement, and any permit applications or inspection records if available. Proper documentation not only clarifies your case but strengthens your position as you pursue a fair resolution. Maintaining a respectful and professional tone in your written communication is crucial. Avoid using threatening language, personal insults, or making accusations that you can't yet prove. Remember, angry or aggressive messages can be used against you in court and might undermine your credibility, regardless of the validity of your complaint. If the contractor fails to respond or resolve the issue, escalate by sending a formal demand letter under Massachusetts General Law, Chapter 93A. This letter should be sent by registered mail or email with proof of delivery and must clearly outline the nature of the deceptive or unfair act in question. To strengthen your legal claim, be sure to state the legal basis, such as violations of Massachusetts General Laws, Chapters 142A or 93A, the remedy you seek, and set a clear deadline for response, at least 30 days. Always keep copies of your demand letter and delivery receipt. These are essential prerequisites before filing a lawsuit under Chapter 93A. If there's still no response by day 30 to 45, send a second and final written notice. Restate your claim and give the contractor one last 30-day window to resolve the dispute voluntarily. Offering mediation or arbitration at this stage is also viewed favorably by courts. When preparing to take a dispute to court, it's important to understand what Massachusetts courts expect from homeowners. Generally, courts require that you make at least 2 to 3 good faith attempts to resolve the issue privately before they will accept a civil case. This means you should document every step you take to resolve the matter, including keeping copies of all demand letters you send, evidence that you provided the contractor with a fair opportunity to fix the problem, and a detailed timeline of your communication attempts. In small claims court, you may be asked to present these records as proof of your efforts. Failing to send a formal Chapter 93A demand letter can have serious consequences, such as making you ineligible to collect treble damages or attorney's fees, even if your claim is otherwise valid. However, there are situations where immediate escalation to state or federal authorities is justified. For example, if there are health and safety threats like exposed wiring, gas leaks, or structural collapse, or if you suspect elder abuse, financial exploitation, large-scale fraud, or contractor harassment and threats, you should not wait. In these cases, acting quickly to protect yourself and others is not only justified, but necessary. Always keep thorough records, as they will be essential if your case moves forward. If you're facing urgent issues, such as the blocking of occupancy permits or forced evictions, it's critical to act immediately. In these situations, you should contact your local building inspector, the Attorney General's office, or even law enforcement without delay. The strength of your case depends heavily on the quality and organization of your evidence. The more clear, organized, and credible your documentation, the better your chances of achieving a successful outcome. Recommended evidence includes a written contract that details pricing, the scope of work, and start and end dates. You should also maintain a timeline of construction phases, documenting what happened before, during, and after the work. Take photos that show all work completed, as well as any work that was not completed. Screenshots of text messages, emails, and call logs can provide valuable proof of your communications. Keep all invoices, receipts, and payment records, as these are essential for demonstrating your financial transactions. Affidavits of truth or written statements from witnesses can further support your claims, and videos of the work site or contractor interactions can provide compelling visual evidence. By gathering and organizing this documentation, you significantly improve your position in any dispute. A crucial step in building a strong case is collecting witness statements and supporting evidence. If your neighbors, family members, or anyone nearby witnessed the incident or contractor activity, it's important to ask them for a written statement or even a video testimony describing exactly what they saw. Encourage these witnesses to write and sign a testimonial or an affidavit of truth, a short, factual statement that confirms the details they personally observed. These signed witness affidavits can be extremely valuable when attached to formal complaints, demand letters, or court filings, as they help establish your credibility and corroborate your account of events. If witnesses have videos, photos, or audio recordings, request clear copies for your records. Organize all such materials in a secure folder labeled Evidence Witness Statements so you can easily include them in your case documentation. Remember, signed witness affidavits and verifiable media evidence not only strengthen your position, but also demonstrate to authorities and courts that your claims are supported by independent observation. This level of thoroughness can make a significant difference in the outcome of your case, ensuring your side of the story is well documented and credible. Organizing your case is a foundational step in managing a housing complaint effectively. Begin by creating a digital folder on your computer or a secure cloud drive to store all relevant documents. For those who prefer physical records, use a 3-ring binder with clearly labeled tabs for each category: contracts and estimates, permits and inspections, photos sorted by before, during, and after, communications, demand letters, and complaints with case numbers. This level of organization ensures that you can quickly access any document when needed. Always save all complaint confirmation numbers when you submit to agencies, as these serve as proof of your actions and can be critical if your case is reviewed. Be prepared to scan and upload all documents to an online portal, as most agencies now require digital evidence submissions in formats like PDF, JPEG, PNG, MP4, or Word. While mailing documents by registered mail is still an option, be aware that it may result in slower delivery, submission, and review, potentially causing delays in your case. By keeping your records organized and accessible, you streamline the complaint process and increase your chances of a favorable outcome. Always use traceable payment methods, such as checks, credit cards, or bank transfers, and avoid paying with cash since it can't be tracked. Use platforms that generate receipts for all transactions. Never pay the full balance until work has been completed and approved by a building inspector. Notarize your demand letters and affidavits to add an extra layer of credibility. Send documents via registered mail with return receipt so you have proof they were delivered. This protects you if anyone claims they didn't receive them. If multiple homeowners are affected by the same contractor, coordinate with them. Group complaints carry more weight in fraud claims. Once you have exhausted all reasonable efforts to resolve your dispute and have thoroughly organized your records, it's time to escalate the matter by filing formal complaints with the appropriate government agencies. Start by contacting the Massachusetts Attorney General's office, which provides a dedicated process for consumer complaints. You can also reach out to the Office of Consumer Affairs and Business Regulation, which oversees home improvement contractor issues and can offer additional guidance. For cases involving broader consumer fraud or online crimes, the Federal Trade Commission and the FBI Internet Crime Complaint Center are valuable resources. If your situation involves more complex or large-scale legal issues, the U.S. Department of Justice Civil Division is available to assist. Each agency offers specific channels for reporting fraud or crimes, including online forms, phone hotlines, and email contacts. Before submitting your complaint, make sure you have all supporting documentation ready, such as contracts, receipts, correspondence, and evidence of your attempts to resolve the issue. Providing complete and organized information will help ensure your complaint is processed efficiently and increases the likelihood of a successful resolution. As a homeowner in Massachusetts, knowing where to turn when you suspect contractor fraud is crucial. The Massachusetts Attorney General's Office Consumer Protection Division is your first line of defense, offering dedicated support through phone, email, and online complaint filing. You can also reach out to the Office of Consumer Affairs and Business Regulation, which provides resources for home improvement contractor complaints and verification. These official channels ensure your concerns are heard and investigated by the proper authorities. Remember, using the correct contact information not only expedites your case, but also strengthens your position as a well-informed consumer. Safeguard your rights. These agencies are here to help. In addition to state-level resources, federal agencies play a crucial role in protecting homeowners from contractor fraud and related scams. The Federal Trade Commission, or FTC, is a primary federal agency dedicated to consumer protection. If you believe you've been targeted by fraudulent contractors, you can contact the FTC directly by phone at 1-877-FTC-HELP or file a complaint online through their secure portal. The FTC's website also offers a general contact page for further inquiries, ensuring you have multiple avenues to seek assistance. For cases involving internet-based scams, or if you suspect elder fraud, the FBI's Internet Crime Complaint Center, known as IC3, is another vital resource. The IC3 provides a dedicated elder fraud hotline at 833-FRAUD-11, and you can submit complaints directly through their website. They also offer a specialized information page for elder fraud, reflecting their commitment to protecting vulnerable populations. By reaching out to these federal agencies, you not only address your own situation, but also contribute to broader efforts to combat contractor fraud nationwide. Remember, reporting fraud at both the state and federal levels strengthens consumer protections for everyone. When contractor misconduct escalates to a federal concern, the U.S. Department of Justice Civil Division becomes a key point of contact for homeowners seeking justice. You can reach the Civil Division by phone at 22-514-2000, by email at civil.feedback@usdoj.gov, or by mailing your concerns to their Washington, D.C. address. For those who prefer digital communication, the Department of Justice also provides an online contact page for direct submissions. Federal laws are designed to provide an extra layer of protection, especially when contractor misconduct crosses the line from unethical behavior to criminal activity. Understanding the difference between civil and criminal violations is essential, as reporting patterns of fraud can help authorities identify and stop bad actors before they harm others. If you suspect you've been targeted by a pattern of contractor fraud, your voice truly matters. Under federal law, your report carries significant legal weight and can trigger serious investigations and enforcement actions. By taking the step to report, you not only protect yourself, but also contribute to a safer environment for all homeowners. Once you've taken the important step of submitting a complaint, whether it's to a local agency, a licensing board, or a court, it's essential to understand what to expect during the process. The agency you contact will typically send an acknowledgement of receipt, which may arrive as an email or a letter. This acknowledgement often includes a case number or reference number, confirming that your complaint has been officially logged. You may also receive a summary outlining the next steps in the process, helping you stay informed and prepared. It's crucial to save all correspondence related to your complaint, as these documents can be vital if you need to reference your case in the future. Creating a secure case folder, labeled with the company name and the date of your complaint, is a smart way to stay organized. Understanding the typical timeline and procedures will help you remain calm and confident throughout the enforcement process. By knowing what comes next, you can better advocate for your rights and ensure that your complaint is handled efficiently and effectively. The investigation timeline for your complaint can vary significantly depending on the agency involved, the complexity of your case, and the current backlog. Each agency has its own standard review period, but understanding these general timeframes can help you set realistic expectations. For example, the Office of Consumer Affairs and Business Regulation typically reviews cases within 30 to 60 days. The Attorney General's office may take 60 to 90 days or even longer, especially for more complex or high-volume cases. The Better Business Bureau is known for its relatively quick turnaround, often resolving complaints within 10 to 30 days. If your case proceeds to small claims court, you can expect a review period of about 30 to 60 days once your claim is filed. Building departments and licensing boards may have variable timelines, depending on the severity and specifics of the issue. Some cases may take longer due to the need for additional evidence or the complexity of the situation. By familiarizing yourself with these timelines, you can better manage your expectations and maintain patience throughout the process. After you've filed your complaint, it's important to know what kind of follow-up to expect from the agency handling your case. Most agencies will only reach out if they need more information from you, if the contractor responds and a mediation attempt is scheduled, or when your case is closed and a final notice is issued. If you don't hear back within 30 days, it's a good practice to follow up with the agency, always referencing your case number to ensure your inquiry is properly tracked. On the other side, the contractor you filed against may respond in several ways. They might deny your claim, offer to settle, ignore the complaint entirely, or even submit a counterclaim. It's essential to document every response from the contractor, even if it's informal or seems insignificant. Keeping a thorough record of all communications will help you build a strong case and protect your interests throughout the process. Consistent follow-up and careful documentation are key to navigating the complaint process successfully. If your complaint does not lead to a satisfactory resolution, you still have several important legal options available. First, you can file a Chapter 93A demand letter, which is a formal notice required under Massachusetts law before pursuing certain consumer protection claims. If you've already taken this step or need further action, you may proceed to small claims or district court, where a judge can hear your case and issue a binding decision. Mediation or arbitration are also viable alternatives, offering a less formal and often faster way to resolve disputes. Consulting with legal aid organizations or an attorney can provide you with expert guidance tailored to your specific situation. Throughout the complaint process, you have the right to be treated with dignity and fairness, to submit evidence and be heard, and to appeal decisions or pursue further legal action if necessary. It's important to remember that retaliation for exercising your rights is strictly prohibited. If a contractor threatens you after you file a complaint, report it immediately to the agency or law enforcement to ensure your safety and uphold your rights.